we'll go ahead and call case number 127215, State of Kansas versus Raine. Will you please state your appearances for the record?
Good morning, Your Honors. Emily Brandt, Appellate Defender Office, here on behalf of William Raine. May I please request 3 minutes for rebuttal this morning?
You said 3?
Yes, please. Thank you.
12 and 3. Okay.
And may it please the court, Christiane, Assistant District Attorney, appears on behalf of the state.
Ms. Grant, whenever you're ready, you can begin.
Good morning, Your Honors. Again, Emily Brandt on behalf of William Raine. We're here this morning to discuss a Terry stop and frisk. I won't go into the facts because I know Your Honors have read the briefing, but I will say if this court finds that there was no reasonable articulable suspicion to support the stop, then this court doesn't need to reach the question of whether or not there was reasonable articulable suspicion to support the frisk. But today, Mr. Raine challenges both. I'll start by saying that I think that it has long been the law in not just Kansas, but in the United States, that presence in a high crime area alone cannot support reasonable suspicion for a stop. And I believe that that is exactly what has happened here. And if this court affirms the district court's ruling, then you will essentially be rendering busy apartment complexes Fourth Amendment free zones. Mr. Raine was simply at an apartment complex here in Wichita late one evening in January, and he appeared to maybe just be standing, maybe just be loitering, maybe knocking on an apartment complex door based on the testimony, when law enforcement officers just pulled into the apartment.
Let me ask you this then. If he was loitering, does that mean he's trespassing? That would give the officers the opportunity to look?
No, Your Honor, I don't believe that loitering and trespassing are the same thing. I mean, sometimes I loiter in my work parking lot, right? I might be talking.
But you have permission to be there. There was a no trespassing sign on this property as I read the record. Is that correct?
I believe that based on the record, there were signs about no trespassing, but there's nothing in the record to suggest that Mr. Raine was told that he could not be at that apartment complex. There's nothing in the record that says that Mr. Raine couldn't be there. And so loitering alone does not mean that you're trespassing. To be trespassing, you must be on land that you have been told you cannot be on, and that there are signs posted that you cannot be there. This idea that an apartment, again, I think that this just goes back to the idea of this being sort of like a high crime area in Wichita. The idea that any apartment complex owner can just sign a blanket trespass affidavit and put up signs, and that gives police officers carte blanche to talk to anybody at an apartment complex, simply cannot withstand Fourth Amendment scrutiny.
Well, here, I mean, it seems like the officers knew that this was an issue at this apartment complex. They drive by, they see somebody standing there, and as they pull in, the guy goes to a door and acts like he's knocking on it, or he is knocking on it. Isn't that correct? I mean, he changed his position when he apparently saw the officers coming, correct?
Well, Your Honor, so did the officers. We have conflicting officer testimony. I mean, everything Officer Jameson says is that Mr. Raine didn't go knock on the apartment complex door until they pulled into the parking complex. But Officer Houston testified that William Raine was knocking on the apartment door to apartment 16.
But we're looking for substantial evidence here,
Right.
and so we're not going to balance those. We're going to go with the one that supports the party with the burden of proof, correct?
Correct, Your Honor. And so I suppose that, but again, what does it matter if within a matter of seconds, Mr. Raine goes from being maybe near his vehicle to then knocking on an apartment complex door? I think that that is just what you do when you go to an apartment complex. You are there to knock on a door or to see somebody. And again, the officers need reasonable articulable suspicion about William Raine. It cannot be that just anybody at an anybody standing in an apartment complex that looks like maybe they're not knocking on a door. They don't know who the tenants of that apartment complex are. They don't know who the social guest of that apartment complex is. There's no reality where they had any articulable suspicion about what William Raine was doing there.
Well, you don't think they had a reasonable suspicion? You know, it's more than a hunch, but it's not very much, correct?
Correct.
And so all they need is reasonable suspicion he was violating any ordinance or state law, correct?
Correct.
Okay, so the criminal trespass ordinance for Wichita says criminal trespass is entering or remaining on any land by a person who knows he's not authorized or privileged to do so. And it doesn't say anything about direct knowledge. I mean, they know. It doesn't mean that anybody particular had to tell them so. And such premises or property are posted in a manner reasonably likely to come to the attention of intruders. So our no trespassing sign meets that second requirement. Would you
Sure.
agree?
Yes.
Okay, so officers are never going to know if a person knows they're not authorized or privileged to remain there. But they can suspect by virtue of the fact it's posted no trespassing, and they know this place has a problem with high crime or loitering, and this guy is standing there when they see him, and he changes his position when they come in.
Your
That
Honor-
doesn't seem like a reasonable suspicion to you?
Your Honor, no, I have to respectfully disagree. I think that that is the case. Again, you render apartment complexes Fourth Amendment-free zones. I think that this is sort of like State v. Sanders, which is cited in my reply brief, where officers say they see somebody who's maybe fidgeting with a car door, and so they pull them over suspecting that maybe they're committing some sort of act of burglary. And the Kansas Supreme Court says, well, no, I mean, you're in a parking lot, it's between a restaurant and an apartment complex. Officers have no reasonable articulable suspicion that that's not the car of that person. I just think that that is not reasonable articulable suspicion that William Raine is trespassing at what has been admittedly talked about as a busy apartment complex, and specifically apartment 16 that Mr. Raine knocked on. Officers knew to have a large amount of traffic in and out. So no, I think that, again, this like blanket idea of this trespass affidavit or signs is just a way to make this apartment complex a Fourth Amendment free zone. Officers are allowed to stop whoever they just see.
Well,
I just don't think that can survive Fourth Amendment scrutiny.
Do large apartment complexes normally have a no trespassing sign?
Your Honor, I could not speak to that. I don't know.
don't
All I
either.
know.
I mean, I'm just curious. This is called a high crime area. I don't really know what the definition of that is. Do you?
Your Honor, I don't, but I do know that high crime areas are not a reason to stop people. And you can see in the district court's ruling, he knows that. He straight up says that it's not supported by case law, but when he thinks about it, he thinks it's incumbent upon police officers to do an investigation when they see someone in a high crime area where maybe there's acts of trespassing.
So you would say the fact there was a trespassing affidavit on file and the officers knew that is really immaterial?
I think it is immaterial. I think that, again, it gives the officers the ability to enforce whatever, should they actually come across a trespasser. But I don't think those things alone are enough to amount to reasonable articulable suspicion that every person at that apartment complex can be stopped for trespassing, particularly here where nobody cited William Raine for trespassing. William Raine wasn't booked on trespassing. This seems quite pretextual to stop William Raine and anyone else that they see at this apartment complex.
Let's assume that there was reasonable articulable suspicion under this city ordinance to at least inquire. Seems like you also have an argument you'd want to make about, could they pat him down? You might move to that argument just as well.
Yeah, correct, Your Honor. So, yeah, if this court finds that there was reasonable articulable suspicion for the stop, which I won't concede there was, then there was not reasonable articulable suspicion for the frisk, which requires a different sort of reasonable articulable suspicion that Mr. Raine posed some sort of threat or public safety risk to the officers, which he just very clearly did not. Again, it's a cold night in January. Mr. Raine is not wearing gloves. I'm sure that all three of you have watched the body camera footage. His hands are in his pockets when the police walk up to him. There's no sound at this point, but they motion at his pockets. He takes his hands out. Officers tell him, don't put your hands in your pockets because I don't know what's in them. They ask Mr. Raine a question. He points back to apartment complex 16. He comes back. He moves to put his hands in his pockets. He stops himself and puts his hands over his chest. And the officer just goes, I don't know you, so I don't know what's in your pockets. I got to pat you down. And pats him down. There was no reasonable articulable suspicion that Mr. Raine was armed and dangerous that was articulated by the officers. In fact, the officers said that this was just sort of a standard of officer safety, which again, under United States Supreme Court jurisprudence, cannot stand.
Didn't the officer or one of them also testify that his continued movements toward his pockets made them question their safety?
Well, I would, one, push back. Again, I know that we're looking at evidence in light most favorable to the party with the burden, but here we literally have body camera footage of what happened, which I think is contradictory to Officer Jameson's testimony. He did not continually try to put his hands in his pockets. He tried to put his hands in his pockets one time and folded his hands over his chest. And so within a matter of 15 seconds, where Mr. Raine is complying with a lawful order, the officer goes to pat him down. So I do not think that it's a fair comment on the evidence that he's like nervously trying to put his hands in his pocket several times.
Are you trying to have us make a credibility ruling then?
I mean, I think that you can. Again, the facts have to be based on substantial competent evidence, and the best evidence is the body camera footage. We can all watch what Mr. Raine does in response to what Officer Jameson orders him to do. And even if Mr. Raine did several times try to put his hands in his pockets nervously, which he didn't, based on body camera footage that we can all see with our eyes, that nervousness does not amount to reasonable suspicion that he's armed and dangerous. The court has said that in State v. Dean. Again, there needs to be reasonable articulable suspicion that William Raine is armed and dangerous, and nervousness alone cannot amount to reasonable articulable suspicion.
So just back to a kind of basic question about this ordinance, could the officers, even before he put his hands in his pockets to warm him up or whatever, could the officers have went ahead and placed him under arrest under that city ordinance?
Well, Your Honor, I don't think so, because I don't think they had reasonable articulable suspicion that he was committing the crime of trespass. Again,
Well, but I, and correct me if I'm wrong, I thought in response to Judge Garner's question that you said that those elements at least had been met, that he's on the land, he's not authorized to be there, and the property is posted.
no, because again, it requires some level of knowledge, and there's no evidence here that Mr. Raine knew that there were these signs posted. I don't believe that Mr. Raine was under any knowledge that he could not be at that apartment complex. And again, it does appear he was a social guest of apartment 16. I know that it happened after the search already occurred, after the frisk occurred, but the older Hispanic gentleman who lived in apartment 16, although he initially didn't recognize William Raine, said that he did recognize Mr. Raine. So again, I don't believe that there was, I don't concede that they could have arrested him for trespassing, because then I would have to concede that there was reasonable suspicion that he was committing that crime. I don't believe that exists here.
Well, you anticipated what my next question would have been.
Well, how about the officer's observation of his inconsistent statements, that he was there to see a woman at room 16, and then changed it to be a Hispanic male?
Well, Your Honor, I guess I don't know exactly what to make of those inconsistent statements, except that all the officers testified that apartment 16 is a very busy apartment. I don't know why, just because an older Hispanic male is on the lease doesn't mean that a woman doesn't also live there, or that a woman wasn't there the last time Mr. Raine was there. So I don't think that those inconsistent statements amount to anything. And to the extent that they do, why would it matter? The officers needed reasonable articulable suspicion that Mr. Raine was committing or about to commit a crime at the time they stopped him. Reasonable articulable suspicion about a crime to support that stop can't manifest based on whatever they tell him when they're interrogating him. That would be for something different, right? Like we might be talking about, you know, an arrest for trespassing or something like that. But to stop somebody, officers needed reasonable articulable suspicion that he was committing a crime. And they didn't have that at the time they pulled into the apartment complex to stop him.
You're a little bit over 13 minutes, so if you want to save a couple minutes for rebuttal, you might just wrap this part up.
Sure, Your Honors. We would just ask that this court vacate Williams' convictions for possession of methamphetamine and paraphernalia, and remand with directions to suppress the evidence that was seized in violation of Mr. Raine's Fourth Amendment rights.
Thank you. Ms. Allen?
Good morning, and again, may it please the court, Christy Allen on behalf of the state. Yes, we are here on the denial of a motion to suppress. The facts as discussed include that there must be reasonable articulable suspicion, and what we have in this case is we have officers who work this Broadway corridor who testified that it is a high crime area. That definition is not provided in the record, so we don't know what those high crimes are.
So we don't know if it was drug activity, prostitution,
We do.
trespassing?
Correct, we do not. We know that they were classified as high crime. I think Officer Houston classified it as significant crime, but we don't know what those crimes were.
And room number 16, and we've heard so much this morning, just to refresh my recollection, there was some testimony of specifically about room number 16.
Yes, the officers testified that they were well acquainted with the occupant of room 16 because they had, quote, a lot of issues with that unit.
But again, not identified as a drug
No,
officer or
just a
anything.
lot of traffic coming and going is what the officers said.
Just frequent traffic.
Correct. And so what you have is you have officers who have this trespass affidavit. They know that this apartment complex, this specific complex, in contrast to Sanders that opposing counsel cited, this specific complex has had issues with crime. And as they're driving by, they see somebody that they are well aware of and acquainted with the behavior, behaving in a manner that they're familiar with for the crime that they believe is occurring.
Were they acquainted with Mr. Raine before?
No,
Okay.
they were not, no. And so as they're driving by, they see a person that they observe to be committing the behavior that they're used to seeing for the crime of trespass possibly. So they turn around to contact him. And when they turn around to contact him, he again exhibits behavior that they're accustomed to in that situation. People then, once they see officers, start to walk towards a door. And so all of this for them is it's checking boxes in their mind. This is something that we're used to seeing. And not only that, but he was going to an apartment where they have had issues. And so that gives them the reasonable, articulable suspicion to stop this person. This person exhibiting the behaviors in a high crime area, matching the behaviors that are often observed by those officers.
And for
those
what
crimes.
purpose? To investigate whether this is a criminal trespass?
Correct.
And was this, I'm pretty sure it was, but my notes only said the evening. I assume since this is January, it was dark outside, right?
It did appear, if you watch the video, I believe it appears to be dark, but, and that brings me, well, that gets us to the frisk part, the articulable suspicion for the frisk
Before you
portion.
move on,
Yep.
do you agree then that we shouldn't consider his change of story at all in looking at reasonable suspicion?
I don't believe that the change of story in the reasonable suspicion for the stop. I believe that the change in story goes to the reasonable suspicion as part of the, and I will be careful because I think as you watch that video, it's all kind of happening simultaneously. They're having the conversation. So because we have that 30 seconds of silence, there's obviously conversation going there. And so one can only assume that that's when he first said, I'm coming to see a female. And at that point, he has now provided information inconsistent with the officer's knowledge. The officer's knowledge is, we know a female doesn't live in this apartment. So this again goes to continuing the suspicions. And I will say, when you watch the video, officers pull in, he does not have his hands in his pockets. As he approaches the officer, he bypasses the pockets with the gloves, and he goes to the pants pockets. And there's nothing in the record to suggest that he put his hands in his pockets because it was cold. He never said it was cold. It was January. Sometimes January is very cold in Wichita. I think we had 60 degrees in Wichita this summer, or this winter in January. So that the cold articulation was never in the record. We do not know that for certain. But what this officer explains is,
So is the cold argument statements of counsel?
yes.
All right.
So what we have is approaching the officers, placing his hands not in the jacket pockets with the gloves, but in the pants pockets. He's provided information that is inconsistent with the officer's prior knowledge. He then removes his hands from his pockets at the officer direction that we can assume based on the actions in the video. And what you'll notice is when he goes to place his hands in his pockets that second time, counsel asserts that it's on his own volition that he stops. But if you watch, the officer simultaneously is pointing to his hands at the same time. So it could be, could be simultaneous, but to say that, oh, he realized and he moved it all on his own, possibly the officer is moving to pointing at his hands. Maybe he's being reminded at that time. But again, it was significant to the officer that He was bypassing the gloves, he was going to the hands in his pants pocket.
So the suspicion is that he may have a weapon, and they just wanted to ensure that he did
Correct.
not have a weapon.
Correct, especially since they have no prior knowledge of this individual. They don't know if he's known to carry a dangerous weapon. And in this high crime area, they determine, we don't know you, we need to make sure that we're safe.
Did they testify about their concern for their safety?
I believe one officer said that he did it for officer safety. And I will draw the distinction, the cases cited by opposing counsel, that of State v. Burton and State v. White, in those cases, you read those cases, and as soon as the officer makes contact, they're patting down the individual. And they say, it's part of my routine, it's just part of what I do. In this case, you don't have the officer immediately going to pat down the individual. He sees the hands in his pocket, tells them to remove it, they're getting the inconsistent story, they're getting the inconsistent information, goes to put his hands in his pockets again, and that's when the officer's like, I'm just gonna pat you down to make sure you don't have anything dangerous. So it is the state's position, Your Honor, that there were particular facts for this specific defendant that gave rise to articulable reasonable suspicion that allowed the stop and the frisk. If there are no further questions, we would just ask that you affirm the district court's decision. Thank you.
Thank you. Ms. Brent?
Your Honors, I'll just be brief. Again, I think that we've heard a lot about how this specific area is a high crime area, about how this specific apartment complex might have issues, etc. I do not believe we've heard anything, and I don't believe the district court heard anything about how William Raine, at the time police officers stopped him, there was any reasonable articulable suspicion that he, the individual, not he in a specific area, not he in a specific apartment complex, that he, the specific individual, was committing or about to commit any crime. I do not believe there was any reasonable articulable suspicion for the stop in this case, and I believe if this court affirms the district court's ruling, you really are just rendering apartment complexes Fourth Amendment free zones, which the Kansas Supreme Court has said we cannot do. We keep repeating this phrase, high crime area. The district court relied on it being a high crime area. It is very clear under jurisprudence that being in a high
But
crime.
wait a second, I thought you said earlier the district court didn't make that as a condition of his finding.
No, he did. He said it was incumbent upon police officers in high crime areas to investigate. And he said it's not based on, the district court admitted this is not based on case law, but when I think about it, it's incumbent upon police officers.
So he was looking at the totality of the circumstances.
No, I believe he was making a blanket ruling that if officers are patrolling a high crime area, they're allowed to investigate people.
And under your view, what would allow a law enforcement officer in this similar situation to investigate an individual in that parking lot for criminal trespass, say?
Your Honors, I guess I don't know because I don't believe Mr. William Raine exhibited any of those behaviors, so
But you're saying they would need more than what they have. What more would do it in your opinion?
you know, I don't,
Can they never investigate for criminal trespass?
I don't think that's the case, Your Honor, but I certainly don't think that a person just, I mean, loitering just means standing. Loitering means that somebody is standing in an area. The officers don't say that they have observed him perhaps loitering for any extended period of time, or looking into car windows, or maybe knocking on several apartment doors to see if he could get anybody to answer, or jiggling apartment complex door handles to see if maybe they were unlocked and he could get in to do something, etc. There's none of that. They literally just see William Raine standing at the apartment complex and they stop him. That simply cannot be enough for criminal trespass at a very busy apartment complex. They don't know if Mr. Raine is an occupant of one of the other apartment buildings, a social guest of somebody there. There's no reasonable articulable suspicion that Mr. Raine was committing any crimes. And he certainly wasn't arrested for the crime that they allegedly suspected that he was committing. And so I don't think there was any reasonable articulable suspicion for the stop. I also don't think there was any reasonable articulable suspicion for the frisk. I believe that Mr. Raine was lawfully complying with the officer's orders at the time of the pat-down, and that there was no reason to individually suspect that Mr. Raine had anything in his pockets, particularly when his hands were not in his pockets. If this court doesn't have any further questions, Again, I would ask that this court vacate his convictions and remand for suppression of the evidence. Thank you.
Well, thank you both. It was refreshing to hear about something other than arbitration. Not that we didn't enjoy that, but we needed a little something different, so we appreciate that. As you know, we will take this under advisement and get the opinion out to you as quickly as we can.